This presentation will cover the application process, approval criteria, and hearings. We'll go over a general step-by-step process of what an application goes through to help you know what to anticipate when filing an application. We'll talk about the statutory criteria for those applications. We'll start with a video covering the application process.
This video is part one of a three-part video series describing the administrative process that is followed for water rights applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part one of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part two of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they disagree with the decision. This is shown in the second part of the blue section of this chart. Part 3 of the video series covers the administrative process once an application is approved with established time limits and the applicant works to complete the proposed project and fully place the water to beneficial use. Now let's take a close look at the beginning of the process from filing the application to a decision by the state engineer. As authorized under Utah Code Title 73, Chapter 3, an application to appropriate, permanent change, or exchange application can be filed. The application can be received by either our main Salt Lake office or one of the 7 regional offices across the state. If the received application is determined to be acceptably complete with the appropriate application fee, it is filed and the information becomes available on the division's website and a master file jacket is created. If the received application is not acceptably complete, it will be returned to the applicant with an explanation of the deficiencies. Determining that an application is acceptably complete does not mean that the information it contains is correct. It only means the required information has been supplied for an application to be filed. The master files for all applications are stored and maintained in our main office in Salt Lake City. The application review process begins in the regional office that has oversight of the geographical area where the application is proposing to divert and use water. Once an initial review of the filed application is made, the regional office staff will then designate the application for advertising in a newspaper of general circulation in the county in which the source of supply is located and where the water is to be used. In some instances, applications may need to be published in more than one paper. I should point out here the importance that the applicant ensure the application they are filing is correct. If there are errors or corrections made after the publication, the application may need to be re-advertised. This will cause a delay in the process. Applications are advertised for 2 successive weeks. Administrative Rule R655-6 designate adjudicative proceedings of the Division of Water Rights as informal. Therefore, any person interested may file a protest within 20 days after the notice of the application is published. After the publication is completed, a proof of publication is sent by the newspaper to the division to confirm the publication did occur as required. There are limited circumstances defined in Utah Code that may not require the publication of an application. An application for a small amount of water, which is defined as 1 domestic, quarter acre of irrigation, and 10 equivalent livestock, is at the discretion of the state engineer. These types of applications may not be advertised. However, notice of these applications will need to be given if the proposed application for a small amount of water may impair existing rights. Temporary change applications are another type of application that notice is not required. However, in the case of a temporary change, if there is reason to believe it will impair an existing water right, it will be denied. After the application is advertised, the protest period has ended, and the proof of publication has been received, the regional engineer will make a preliminary review of the application and all documents and information. This preliminary review would include a policy review, potentially an initial field review, and data collection. If the regional engineer determines there are now additional parties, protestants, to the application, and there isn't sufficient information to determine if there is reason to believe the application meets the statutory criteria within Utah Code Title 73, Chapter 3, that is applicable to the type of application they are reviewing, an informal administrative hearing will be scheduled. Administrative Rule R655-6 gives authority and defines administrative adjudicative proceedings of the Division of Water Rights. The administrative hearing is scheduled with the Assistant State Engineer for Applications and Records and the Regional Engineer. At least 10 days' notice is given to all parties. Most hearings are held in the county where the water source is located or the county where the majority of the parties reside. Hearings may be held outside the county at the discretion of the state engineer. After the hearing, or if no hearing is needed, the regional engineer will then complete a full review of the proposed application and all associated data to determine if there is a reason to believe the application meets the statutory criteria to be approved. This full review may include a field investigation, review of the appropriation policy for the area, review of scientific data, and a full file review, including title of record with the Division of Water Rights, the protestants' concerns, and any additional information received before, during, or after the informal administrative hearing. Based on the regional engineer's findings, a recommendation is prepared and reviewed with the application and record section. A final draft decision is then prepared for review of the state engineer. The state engineer then reviews the decision, consults with the regional engineer and assistant state engineer. The state engineer will then render a decision to approve with conditions, or reject the application. The decision of the state engineer is served on all parties to the action. Part 2 and Part 3 of this video series will discuss the administrative procedures following a decision of the state engineer.
Now we're going to talk about application approval criteria and the legal framework the division works through. We'll focus on the processes for applications to appropriate, change applications, and exchange applications. These are the three most common applications submitted to the division. All of the decisions that come out of the state engineer's office are guided by a legal framework within Utah Code. Every application goes through the process using the set legal framework, so the same statutory criteria are applied each time. Each application falls within a specific part of Utah Code. For example, applications to appropriate generally fall within Title 73, Chapter 3 of the Utah Code, Section 8, or Utah Code 73.3.8 is where you will find the application to appropriate criteria. 73.3.3 covers change applications. 73.3.5.5 covers temporary applications. Fixed time applications are covered in 73.3.8. Finally, exchange applications are under 73.3.20. Let's look at some important elements from the code that were mentioned in the video. One of the important elements is the 20-day period when an application may be protested. Just because an application is protested does not mean that application is automatically denied. The division still goes through the process to evaluate the application and the data that has been submitted. Another element is the holding of administrative hearings. This is an informal process. In many cases, attorneys participate in those hearings, but an individual does not need an attorney to participate, and having an attorney present does not necessarily provide an advantage. For the decision-making process, we look at the facts and the data that is presented, and we follow the statutory approval criteria. So let's look at approval criteria. The state engineer makes the decision on an application, whether it be to approve with conditions, or reject the application. The approval criteria with every application is a standard known as the reason to believe standard. If you were to rank standards, a reasonable suspicion would be the lowest burden to overcome, and then the highest burden would be beyond a reasonable doubt. Between these, the reason to believe is just above the lowest standard. This means if an application is filed with the division, the applicant just needs to give a reason to believe that the application can be approved as it meets the statutory criteria. Whether it's an application to appropriate, a change application, or an exchange, that reason to believe standard is used when the application or the data is evaluated. Looking at the statutory or the legal framework for applications, under Utah Code 7338, it states that it shall be the duty of the state engineer to approve an application if there is reason to believe the following elements. First, in the case of an application to appropriate water, whether there is unappropriated water in a proposed source. In most cases, there are specific area policies that have determined there may be limited amounts of water that can still be appropriated. You'll find on our website a map that identifies the appropriations policies for each area. Some areas are open to appropriations. Some areas are restricted where, for instance, there may only be water available for small domestic applications. Other areas are completely closed and may be over-appropriated. In those areas, you cannot be approved on an application to appropriate. To initiate a new use of water, you would need to do a change application to convert an existing right. Another criteria defined under Section 8 is that the proposed use cannot impair existing rights nor interfere with a more beneficial use of water. The division needs to make sure that those proposed appropriations or changes do not impair existing rights or interfere with beneficial use under other water rights. This would generally include the criteria of change applications staying within the drainage in which the water right originates. For example, it would be impossible to change a water right from the Sevier River drainage into the Provo River drainage. Another element within the change application framework found in Utah Code Section 7333 says that if a change does impair an existing right, the applicant may need to provide just compensation or adequate mitigation must be made. But generally, a change should not impair another right. There are also statutory criteria if quantity impairment is raised, or a rebuttable presumption of quantity impairment is raised. It is the applicant's burden to prove that there is evidence that quantity impairment has not occurred, or that they can overcome the rebuttable presumption. Keep in mind that there is a difference between quantity impairment and a rebuttable presumption of quantity impairment, but they are related. Another portion of Utah Code, Section 7338, regarding appropriations, says that the state engineer shall reject a permanent change application if the applicant is unable to meet the burden of overcoming that rebuttable presumption of quantity impairment. Therefore, it is important that the applicant participate in this process with their application. Now, let's look at temporary change applications. These can only be approved for 1 year. In 2015, a slight alteration was made to statutory criteria for temporary changes. They are no longer advertised and have no hearing associated with them. The main criteria the division looks at for a temporary change application is if there's reason to believe it will not impair other rights. If it appears there is potential for impairment, that application will be denied, and the applicant will need to pursue a permanent change so that it can actually be evaluated more deeply, get public comment, and go through an investigation. One of the key things here is if you're not sure on a project and you're thinking a temporary change application may be appropriate, you might want to visit with the regional engineer in the area where you're working, and they will help you determine whether a temporary or permanent change is most appropriate. Pre-application consultations are allowed by statute, and the state engineer encourages them. Again, temporary changes are for 1 year, so if you have a project that's a longer term, you might want to do a permanent change application. Exchange applications are another common type of application. They are covered under Section 73.320 in Utah Code. An exchange application is typically filed when you have a diversion from one water source and you're exchanging it for another. The statute requires that there be no diminishment in quantity or quality of the water being exchanged. Exchanges must stay within the drainage in which the water right originated. For all types of applications just discussed, Utah Code also sets the criteria that the proposed plan is physically and economically feasible, and that it will not prove detrimental to the public welfare. Because of the reason to believe standard, an applicant does not need to have complete drawings on the project, nor provide financial data showing it is all paid for. The applicant just needs to give the state engineer the reason to believe that it's physically and economically feasible. That being said, the hurdle for a reason to believe may vary based on the proposed project. For example, if you're building a home, you probably do have that financial ability to complete what is proposed in the application. However, if you're proposing a very large project, such as a nuclear power plant on the Green River, there would be a much higher standard to show that you have the financial ability to complete that project. Within Section 73.3.11, there are some suggestions of items to include in the Statement of Financial Ability on an application. This could include providing the articles of incorporation, the names and places of the board of directors, and the capital that is committed to the project. Code also sets criteria that the application is filed in good faith and not for purposes of speculation or monopoly. In other words, someone can't just come in and gather up all the water under an application and then grow rich off of selling it. Filing in good faith means there should be a project that's proposed, not speculating over that water. In 2008, there was a case where the court concluded that the original application was filed for speculation or monopoly because the only proposed beneficial use of water was a plan to sell it to others. Indeed, the applicants had no lands, facilities, customers, or contracts. It should be noted, as outlined in Utah Code 73.5.15, if there is a groundwater management plan that has been adopted in the area, the application must comply with that groundwater management plan. There aren't groundwater management plans in every area of the state, but wherever they have been adopted, the application must comply with its provisions. Looking at Section 8, if the state engineer has reason to believe that an application will interfere with the more beneficial use of the water, or unreasonably affect the public recreation or natural stream environment, the application may be held until the matter is investigated. Now we'll turn to hearings. The purpose of administrative hearings is to help the division understand the application better, including what is being proposed. It also allows other parties to an application besides the applicant to be part of the conversation. Hearings allow the division to ask questions of the applicants and any protestants. The process for scheduling a hearing is as follows. The regional engineer will contact an assistant state engineer to coordinate a date and time. Notices are then sent to all involved parties. Party participants are the applicants, protestants, and the state engineer. Hearings are scheduled under the Administrative Rule of Utah Code R655-6, which outlines the criteria for a hearing. Hearings may also be held if it is requested in a timely protest, or hearings may be held at the discretion of the division, even if a protest hasn't been filed. If there are no other parties besides the applicant, to make the process a little quicker, the regional engineer may just reach out to that applicant and schedule a meeting with them instead of a formal hearing. Often that is dependent on the need to gather information. As mentioned before, proceedings are informal, so an attorney is not required. Hearings are open to all parties, and the purpose of them is to introduce evidence to us to consider, to examine and cross-examine witnesses, to make arguments, and to fully participate in the proceeding. Hearings help the division gather information needed to make a decision on the application. Non-party participants may also participate in a hearing. Party participants are the applicants, protestants, and the state engineer. Non-party participants may be someone like an engineer, geologist, or attorney acting as a witness for or speaking on behalf of a party. Following the hearing, if a party believes that they are aggrieved by the decision of the state engineer, they have the option to file with the state engineer a request for reconsideration, or, with the court, judicial review of that decision. To review, the purpose of the informal hearings is to gather data and information that's relevant for the state engineer to determine if the application can be approved with conditions, or if the application should be rejected. To do that, they will look at whether there is unappropriated water, whether it will impair existing rights or interfere with the more beneficial use of the water, whether the project is physically and economically feasible, whether the applicant has the financial ability to complete it, whether the application is filed in good faith, whether it will impact the public recreation or natural stream environment or prove detrimental to the public welfare, and whether it complies with a groundwater management plan for the area. Knowing the criteria can help both applicants and protestants be prepared to make their case during the hearing. This can also help them avoid making arguments for or against the right based on material the state engineer does not have authority to consider. For example, if a protestant objects to a right based on zoning rules, the state engineer cannot consider that as a valid reason to reject an application. Let's move to policies that are specific to different regions. When filing an application, the applicant should be aware of the policies specific to the region. These policies can be found on our website or by contacting your regional office. Examples of the different policies impacting certain areas. The Salt Lake Valley has a groundwater management plan in place that all change applicants should be aware of. In the eastern region, the Colorado River policy and endangered fish policy affects a lot of applications. There's a special policy for the Weber Delta sub-area of the east shore of the Salt Lake that affects applicants working with the Weber River Area Office. There are Milford and Blackrock policies affecting applicants in the southwestern region. There's a policy within the Sevier River Basin. There are many more policies specific to different basins and river systems in each region. It is generally helpful if applicants are aware of the policies in their area. Let's move on to the way an application may be approved. The state engineer can approve an application as submitted, meaning the application is approved with the details specified on the application. Or the state engineer can approve an application with conditions, meaning the applicant must follow the conditions the state engineer has outlined as part of the approval. When an applicant receives an approval, it's critical they read the approval and understand any conditions that apply. Some of those conditions might be a change application might be approved with a condition that diversions and depletions are not exceeded from their historical amounts. The approval may require measurements of usage and reporting of that data. A change application to move from one well to another may require you to permanently abandon and seal the old well if it has no other rights on it. Another condition would be that the prior use must cease in order to develop a new use. Something has to be given up in order to get something new, so you've got to retire that prior use and demonstrate how you've been able to do that. A change application based on shares of stock in an irrigation company might have a condition to maintain shares. If you fail to maintain them, the water company could ask for a reversal of that decision by the state engineer. If the applicant does not own the facilities where their water is being diverted from, there may be some limitations associated with that. The state engineer cannot grant access to or easements across property. Another condition would be the transfer of ownership of the water right, if the change application proposes use by a municipality. For example, if the water is to be used by Lehigh City, proof would need to be filed by the city. The prior owner or developer would not be able to file proof because it's not their facility. The application actually would need to change ownership to the city. If distribution regulation is part of the conditions of approval, you may need to report and only take your water under the direction of that river commissioner. In summary, the state engineer evaluates applications by a legal framework of specific statutory criteria. That criteria specifies that it shall be the duty of the state engineer to approve an application if there is reason to believe the statutory criteria. That could be a full approval of the application, or it may be approved with conditions. Finally, if an application does not meet the requirements of the law, then it shall be rejected. We're going to watch another video detailing the next part of the application process.
This video is part 2 of a 3-part video series describing the administrative process that is followed for water right applications. This multi-step flowchart you are seeing was created many years ago to visually diagram the process from filing to certification. We will use this chart in the video series to describe the administrative steps that are completed once a water right application is filed. Part 1 of this video series covers the application process from filing to decision of the state engineer, which is shown in the first portion of the blue section of this chart. Part 2 of this video series describes what happens to an application after the decision is rendered and the administrative remedies parties may seek if they believe they are aggrieved by the decision. This is shown in the second portion of the blue section of this chart. Part 3 of this video series covers the administrative process once an application is approved, with established time limits, and the applicant works to complete the proposed project and fully place the water to beneficial use. The water right application process shown is authorized under Utah Code, Title 73, Chapter 3, for appropriation of water. This flowchart process is applicable to applications to appropriate, permanent change applications, and exchange applications. There are other authorized types of applications that follow similar administrative steps or portions of these steps. However, this video is intended to focus on the administrative process for these 3 most common water right applications. For part 2 of this video series, let's now take a close look at what happens once a decision is issued by the state engineer and the administrative remedies a party has if they believe they are aggrieved by the decision. Once a decision is issued on a water right application, that decision may approve an application, reject an application, or approve an application with conditions that must be met by the applicant as they proceed with their proposed project. The decision is served on all parties to the application. All parties include the applicant and all the protestants to the application, and of course the state engineer. The decision is issued as an order of the state engineer. If the parties accept the approval of the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As part of the conditions under which an application is approved, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. The time limit given is generally 5 years from approval of the project. For larger projects, additional time may be allowed. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code, Title 73, Chapter 3 for approval, the application shall be rejected. If the parties accept the rejection of the application ceases. In some cases, a party to the application may believe they are aggrieved by the order of the state engineer. The order of the state engineer is subject to provisions of Administrative Rule R655-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act and Utah Code, Section 73-314, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. A request for reconsideration must be filed in writing with the state engineer within 20 days from the date of the order. The written request shall be filed in person, by mail, or electronically. If the request is filed electronically, it shall be submitted to the authorized general email for the division, which is waterrights@utah.gov. When a reconsideration request is received, the division will send notice of the request to all parties and may, within 20 days from receipt of the request, deny or approve the request in part or in whole, issue an order, or rehear the application. If the state engineer does not issue an order within 20 days from the date of the request for reconsideration, the request shall be considered denied. A request for reconsideration is not a prerequisite for filing a judicial review. If the reconsideration request is granted, all parties to the decision are notified. Granting of a request for reconsideration sets aside the administrative decision on the application in its entirety, and the status of the application reverts back to the status prior to the order of the state engineer. The regional engineer then reviews any additional information and conducts further investigations to determine if there is reason to believe the application meets the statutory criteria for approval. Another informal administrative hearing may be scheduled. The result of this investigation and new determination is an amended order of the state engineer. The amended order is again served on all parties. If the parties accept the amended order approving the application, including any required conditions, the applicant can then work to develop the proposed project to place the water to full beneficial use. As with the original order, the state engineer will set a time in which the applicant shall construct the works, apply the water to beneficial use, and file proof with the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the state engineer does not have reason to believe the application meets the statutory criteria within Utah Code, Title 73, Chapter 3 for approval, the application shall be rejected in an amended order of the state engineer. If the parties accept the rejection of the application ceases. If a party still believes they may be aggrieved by the amended order of the state engineer, as with the original order, the order of the state engineer is subject to provisions of Administrative Rule R655-6 of the Utah Division of Water Rights and to sections of Title 63G, Chapter 4 of the Utah Administrative Procedures Act, and Utah Code Section 73-3-14, which provide for filing either a request for reconsideration with the state engineer or for judicial review with the appropriate district court. The result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order of the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. Now let's look at the remedies if reconsideration was not granted. A party may, within 30 days, file for judicial review with the appropriate district court. Again, the result of a judicial review will be a decision by the court. The decision may be consistent with the order of the state engineer, or it may reverse the state engineer's decision. If the court's decision approves the application, the applicant may proceed with developing the project. If the order by the court rejects the application will cease. A party may file for an appeal of the district court's decision with the Utah Supreme Court. If the original order approved or approved with conditions and the reconsideration was not granted and no judicial review was filed, the parties accept the decision. The applicant shall then complete the project as approved and fully place the water to beneficial use within the time limit established in the order of the state engineer. Part 3 of this video series will cover completing and proving the project is complete. If the original order of the state engineer rejected the application, the reconsideration was not granted, and no judicial review was filed, the parties accept that decision and the application ceases. Orders of the state engineer approving an application will include a time limit in which the applicant shall complete the project and place the water to full beneficial use. Part 3 of this video series will discuss the administrative procedures following the approval of an application.
To reiterate what the video outlines, if a party feels aggrieved following the state engineer's decision, they have 20 days to ask for reconsideration of that decision. They would file that with the state engineer's office, who would then send out notice to all parties. If reconsideration is not granted, they would then have 30 days to file a judicial review. Alternatively, A judicial review may be filed directly within 30 days from the initial decision, skipping the request for reconsideration step. The important thing to note is that there are remedies that parties can seek if they feel that they're aggrieved by the decision of the state engineer.